Jeez, yeah. Oh boy. Hi.
Check outside.
Go ahead and go on the record. We're on the record, JT, on the matter regarding this is the reset permanency planning hearing. We'll go ahead and get appearances from everyone on the screen. The court will note there is an additional camera in the courtroom pursuant to a media request by our Nevada judges, which the court did sign off on. My understanding is it had been withdrawn during the last hearing due to some exchange with the bench. The court issued a minute order putting this back on calendar as this is one of the hearings that is designated as public by statute. I want to make sure that that was clear. This court's policy is that these hearings are public unless the findings that are required under the statute that it would otherwise be in the child's best interest that they not be public be made. I did not see any filed oppositions to the media request, so the court's going to treat that as valid. Let's go ahead and get appearances.
Michael Salloum with the District Attorney's Office.
Loni Pollard, permanency specialist.
We're grandparents of.
And the placement, correct?
Yep.
Yes.
Okay. Lou, I think I heard you make an appearance, but I think I got you and Mike at the same time, so we'll just make it clear Louis Schneider is present. Mr. Jacks, did you make your appearance?
Not yet, Your Honor. Good afternoon, Your Honor. David Jacks, bar number 12409, for who's present. Your Honor, I would also like to point out I did not receive a copy of the order. I have tried to receive a copy of the orders. I've had great difficulty in this case getting a lot of documents for some reason from through the Register of Actions, either through Odyssey or through the new system. I can't remember what it's called. So I never got a copy of that order. Moreover, Your Honor, I never got a chance, since I didn't get a copy of that order. I did receive the minute order, and I do understand what you're saying, but I never did file an objection because I never got an order for that anyway.
If you want to make a record, I'll certainly allow for it. I am showing you in Odyssey as being attached to the case. I'm not sure why you're not receiving them. The original media request did go out by our normal electronic service means through the program, so you should have received one. I don't know if there is an issue with the registration of your email or if it's an internal problem. We've certainly make a note of it in the minutes and get a message out to the clerk's office to make sure that you're getting full access.
Thank you, Your Honor. I appreciate it. And not that I have a problem with them being here today or anything. I just wanted to, it's like for the future, just in case, if I do have a problem, I'd like, I need to have the documents.
That's fine. Yeah, the media requests are by nature ex parte, but they do get filed into the order and should have been distributed on the email list. And so if that did not happen, that's a failing of the program, and we'll make sure that that gets sorted out.
Thank you, Your Honor.
Anybody else need to make? I know we've got parents present. We've got present as well by video. I see Attorney Kyle King Kyle, are you just sitting in to monitor?
Calendar said I had a trial.
A trial?
Why not?
You don't.
Well then.
The only thing I've got on calendar today is this review hearing. I don't know if a trial is vacated or not, but I'm not showing one on, so you're off the hook.
All right, well, it was a pleasure to see everybody. Have a great day.
All right, have a good afternoon. Okay.
Your Honor, I did make one record. I did not see Sean Lytle, the cap, had been notified of the minute order either. I know Miss Sape, who's this case that says I'm covering for today, did reach out to Mr. Lytle and let him know there was a hearing today. I don't believe she ever heard a response back from him. I just want to make the court aware that he wasn't notified and we did notify him.
All right. Let me make sure that he's showing up as counsel record for the trial. He is. So what I'll do is I'll have my JEA look into this, and we'll double check with the clerk's office to make sure that everybody on the service list is getting it. It looks like the Children's Attorneys Project has got the star next to it, and that's probably the problem. We've been experiencing this with several other cases that do have private cap counsel. And for some reason, Odyssey is identifying the Children's Attorneys Project itself rather than the individual attorney as the attorney of record. So we'll make sure that that is also addressed. Did Ms. Sape say whether or not he raised any objection to the hearing going forward?
She actually never responded to him, Your Honor. I know she was planning on potentially filing a brief, but given the fact that we did not receive any word from Mr. Lytle, she opted not to, because most of her briefing that was requested at the last hearing would have been essentially on behalf of the child, and that would be Mr. Lytle's position, not ours. So,
all right.
Last I heard, she hadn't heard back yet.
Yeah. Okay. Just put the parents at ease a little bit with respect to the open nature of this particular proceeding. The media request was specific that the child's face would not be used, the parties' faces wouldn't be used, and the child's name would also not be used, so that we were in compliance with the 432B statutes. The public, when they attend these, and the press do still have to abide by the privacy provisions in for the 432B that prevents the release of specific reports and different things like that. So just so that you understand, the court is trying to balance the public's interest in an elected official's job and being able to make sure I'm doing it correctly, and the individual family's privacy concerns. I do, in reviewing the report, I see that Judge Hardcastle did make findings and set this for a continued review hearing down the road. That's currently set for November 17th at 2 p.m. I also see that a 555 hearing was set for September 22nd at 10 a.m. In reviewing the minutes, it appeared that there was some resistance on the part of the department with respect to moving forward. Well, maybe not the department, the state. It wasn't really clear to me. The department outlined compelling reasons to keep reunification as the permanency plan here, and outlined the parents' compliance with their case plan. And as near as I can see, they are 100% in compliance with the case plan requirements. And that 555 hearing, though I don't see it memorialized in any of the past minutes, the representation from Ms. Sape was that there was a stipulation that a 555 hearing would be held regardless of the ultimate outcome of the criminal case, which I think is scheduled for trial in December. Is that everybody's understanding of the agreement and the negotiations from the start? Because the report did refer to it not as 555 presumptions, but stipulations. And so and then I also noted the state made some reference to a stipulation that would be heard. It just had not made it to the minutes at the time of the plea hearing. And so I just wanted to double check and make sure everybody is on the same page that way.
That's my recollection, Your Honor.
Okay. All right. Just want to make sure. There also was a mention of a request for a psychiatric evaluation to be ordered. It wasn't clear to me what the purpose for that was, but it appeared that if it had been ordered, the state was willing to get that set up without the parents having to go out of pocket for it. Is that right?
That's correct, Judge.
So is that going to be conducted through DFS Clinical?
That's what the intent was, Your Honor. I'm sorry.
I'm sorry. I did. I submitted the referral last week or 2 weeks ago and has spoken to Family Clinical. They were having a hard time submitting the referral because to them it was also unclear why a psychiatric evaluation was needed based on how the case is progressing with the department and the parents' compliance with their case plans and everything that they've needed to complete thus far. So I did request that Clinical reach out to the attorneys, as that sounds like it was requested by the attorneys during the previous hearing.
Okay, so Mr. Schneider, Mr. Jacks, it was your request for the eval. Is it for purposes of the evidence the evidentiary burden that you?
Your Honor, actually, we didn't ask for the judge. We didn't ask for the eval. The eval was brought up, and I said, "Wait a minute, why are my clients having to take a psych eval?" And then someone stated that there was a stipulation early on in the case. And Judge Hardcastle suggested that the state should pay for it, and that's all I agreed to. I don't know that we absolutely need a psych eval. I guess I thought it was the state pushing that issue.
Yeah, look, I don't think we do. If we can all agree that we don't need the psychological evaluation, psychiatric evaluation, we can just go ahead with the plans to hold the hearing. And, it's the parent's burden at this point, given the stipulation pursuant to 555, that they meet the burden in convincing the court with clear and convincing evidence that the child would not suffer psychological or physical harm as a direct result of the burden being overcome and the court directing a placement of the child in the parent's home. But based on all the documents and everything I have supporting these reports, it appears that the parents did get a positive discharge from Red Rock, that the therapists involved saw no need for further therapy with respect to this specific child that is in my jurisdiction. The criminal court's no contact orders as to the other children aren't part of these proceedings anymore, and that will certainly go forward in other general domestic jurisdictions once the criminal case is ultimately resolved. But with respect to this child, the one that the parties have in common, really it's just a matter of getting into the record the things that they've done to comply with their case plans, to get the clinical impressions as to what the risk, if any, there is of psychological or physical harm to the child, and then the court's green light essentially to start reunification proceedings. So that's my position as to where we're at in the case. It looks like the hearing's been set. Looks like our review hearing's been set. It wasn't clear to me if Judge Hardcastle found compelling reasons to keep reunification as the primary plan, but the compelling reasons are, in fact, outlined. Just to summarize, the parents have completed their case plans in substantial compliance. The child is placed with family, with paternal grandparents. The parents continue to visit under the supervised requirements of the court. And based on the interactions that have been observed in the therapeutic visits, everything has appeared to be appropriate. And at least with respect to this child, the parents' relationship with this child appears to be progressing in a healthy way that warrants the court taking a look at the reunification and 555 presumption at this point. That's my understanding from the reports. Does anybody have anything to the contrary, anything they need to add to the records today?
Your Honor, I'm in complete agreement with the court.
Okay. All right. Well, I thank you all for coming back to participate in this particular hearing. And we will certainly look into the issues with Odyssey and why individuals weren't getting noticed on the electronic service issue. We'll get that corrected. Okay.
So it might be something.
All right. The clerk's office is saying that it does require an actual sign up for that electronic service from the attorneys involved when they make the appearance in the family court case and are put on the Odyssey system. So, Mr. Jacks, if you can double check with the clerks and make sure they've got your information correct, that should resolve the problem as to service for you. With respect to the CAP service issue, it's something that did come up in a recent judge's meeting, and we are looking into that from another side, so we'll make sure CAP's on the list to have that fixed as well.
Yes, Your Honor. Just to let the court know, though, I've been in practice for almost 10 years, and this is the first case where I've had it where I can't get a copy of the judge's orders and I can't get a copy of the stuff. But I'll double check to make sure I'm appropriately signed up.
I find it mind-boggling. You've appeared in front of me a number of times, not just on this case, and I figured you were probably getting copies of your reports because you seem to know what's going on in those cases. So it may just be a glitch with this particular case. You might want to follow up with them on.
All right. I appreciate it. Thank you.
Okay. Anybody else have anything for the record today? Okay. Thank you for your participation. That will conclude the hearing today. We'll see you again September 22nd at 10 a.m. for that 555 hearing.
Thank you, Judge.
Thank you, Your Honor.
Thanks.
Thank you, Your Honor.